Welcome to Pass Your Real Estate Exam Study Notes with me, Diana. These are the exact study notes I used to pass my real estate exam, and I hope that you find them resourceful. Check out the link below for more cool resources, and I'd love to connect with you there. All right, let's dive into our study session today on contract legal status. Contract categories. Once a contract has been created, it falls into one of four legal categories. 1 is valid, 2 is void, 3 is voidable, and 4 is unenforceable. Void contracts. A void contract has no legal effect from inception. The stipulations and conditions in a void contract cannot be legally enforced. In its defective state, a void contract couldn't be completed even if the parties wanted to. Voidable contracts. Voidable contracts are potentially valid contracts where at least one party has an option to rescind or terminate the contract without penalty. Voidable contracts involve a party who is incapable of legally entering into a contract, such as a minor or an adult incapacitated by mental illness or the influence of medicine or alcohol. Ratified contracts. When a party performs their obligation to a contract that they could have rescinded, they are said to have ratified that contract. Unenforceable contracts. An unenforceable contract is one that has or had the potential of being a valid contract, but its enforcement is barred by some attribute of the contract or technicality of law. Okay, to be honest, reading that, I probably have to read it again. So, all right, let's do it. Let's cover this one more time. An unenforceable contract is one that has or had the potential of being a valid contract, but its enforcement is barred by some attribute of the contract or technicality of law. I hope that's not on your test, friend. Okay, next. Statute of frauds. The statute of frauds is a state-level law that requires certain types of contracts to be set out in writing to be enforceable, including most real estate contracts. Statute of limitations. Statute of limitation has to do with the state and federal laws establishing time limits for bringing certain kinds of legal actions. All claims must be filed prior to the statutory deadline, or the legal right to press a claim is barred. A legitimate complaint about a performance failure related to a valid contract will not be considered if the statute of limitations has expired. Doctrine of latches. The doctrine of latches is another legal principle that courts use to deny dated claims. Think of this as the use it or lose it rule. If you don't use your right to bring suit, you eventually lose it. Contract classifications. Valid contracts can be classified. I had a long day. Brace with me. I'm going to drink my green juice. All right. Valid contracts can be classified in one or more of the following ways: formal contracts, informal contracts, express contracts, implied contracts, unilateral contracts, bilateral contracts, executory contracts, and executed contracts. 8 classifications equals 4 pairs. The 8 classifications naturally cluster into 4 pairs that can be compared and contrasted for better understanding: formal versus informal, express versus implied, unilateral versus bilateral, executory versus executed. Express agreements in real estate: a listing agreement, a buyer-broker agreement, a sales and purchase contract, and a lease agreement are all common examples of express contracts that you'll encounter during your career as a real estate agent. Implied contracts. Even though implied contracts are established by their parties' actions rather than a written document or an explicit discussion, they can have all of the legally binding power or more explicit contracts and should be taken seriously. Bilateral contracts. A bilateral contract is an agreement in which both parties make a promise to perform the actions specified in the contract. All contracts require two parties, but in bilateral contracts, both parties make promises. Bilateral contracts are typically the contracts of choice for the business world. Unilateral contracts. A unilateral contract is one in which one party, the offeror, makes a promise in exchange for the reciprocal act on the part of the second party, the offeree. With a unilateral contract, the second party is not bound or legally obligated to the agreement because they made no promise. So, in a unilateral contract, there are two parties but one promise. Once the second party, the offeree, accepts and activates their agreement to the terms of the contract, the first party, the offerer, is bound and obligated to fill their side of the contract. Executed versus executory contracts. An executed contract is a contract in which all terms have been fulfilled by all parties. An executory contract, by contrast, is a contract that has not been fully performed. In real estate, contract to closing equals executory. Let's review. This is a great time to support the channel by liking, by commenting. Let me know what part of the real estate exam study session you are on, or if you passed, I'd love to congratulate you. Check out the link for more tools and resources, and subscribe or follow if you haven't done so already. All right, let's review some terms. Statute of frauds. A law requiring certain types of contracts, including those conveying interest in real property, to be in writing, to be enforceable. Statute of limitations. A legal concept that establishes time limits for bringing certain kinds of legal actions. Unenforceable. Lacking the essential elements necessary to be legally binding and obligate performance of a valid contract. Valid contract. A contract possessing the essential elements necessary to be legally binding and obligate performance. Void contract. A contract lacking one or more of the essential elements, resulting in its having no legal effect. Voidable contract. A contract wherein the wronged party has the option to perform, enforce, or void the contract. Bilateral contract. A contract wherein both parties are obligated to perform in an exchange of promises. Unilateral contract. A contract wherein one party makes a promise and is obligated to perform if a second party chooses to accept the offer and perform in exchange for that which was promised. Contract legal status. That concludes this study session. For more study notes, check out all of my other sessions, and I will see you next time. Bye for now.